Good afternoon, everybody, and thank you for coming to today's panel on DEI and the First Amendment. I'm Taonga Leslie, Director of Policy and Program for Racial Justice at ACS and the organizer for today's event. Before we get started, I'd like to take a moment to acknowledge today's National Day of Mourning for former President Jimmy Carter. President Carter devoted his life to public service, mediating conflict, and defending human rights. He was also the first president to appoint significant numbers of women and people of color to the federal bench, with an unprecedented 41 women and 57 people of color confirmed in his term. At ACS, we are grateful for President Carter's contribution to the courts, and we honor his enduring legacy. I'd also like to thank my colleagues at ACS who helped make today's event possible, including Vice President of Policy and Program Christopher Wright DeRocher, and Chapter Associate Senjer Joseph. Now, today we're here because, unfortunately, President Carter's legacy for diversity is under attack. Over the last 18 months, we've seen attacks on diversity at all levels of the law. In 2023, the Supreme Court issued a ruling severely restricting consideration of race in college admissions, leading to sharp drops this fall in Black and Hispanic enrollment at schools like MIT and UNC. More than 100 cases have been filed in federal courts to challenge DEI programs across the country. 14 states have passed legislation attacking DEI, and the incoming Trump administration has signaled that it will ban diversity programs for federal contractors in government on day one. Now, these challenging headwinds have not changed our commitment to diversity, but they are forcing advocates to think creatively how we can use the law to advance inclusion in this new landscape. In late 2020, plaintiffs used the First Amendment to successfully void portions of Trump's first anti-DEI executive order. And last year, the 11th Circuit upheld injunctions against Florida's Stop Woke Act on First Amendment grounds. So today we're going to hear from some of this country's best and brightest legal thinkers about how to navigate tensions between DEI and the First Amendment. And we could think of no better person to lead this conversation than Supreme Court expert Chris Geidner. Chris Geidner is the founder and editor of LawDork, an analysis platform with more than 40,000 subscribers, and he's also a regular contributor to MSNBC, among other national platforms. So thank you, everybody, for joining, and thank you, Chris. I'll pass it over to you to get the conversation started.
Thanks so much, Tonga. I really appreciate the fact that we've brought this group together today, and the fact that we're doing it on this day. As I'm sure I'm not alone in having spent my morning listening to several of the really incredible eulogies to President Carter, and I think his lifetime of service and respect, and as President Biden not so subtly referenced, character, I think will be front and center in our discussion today. Before we start, I just want to highlight the incredible panel that we have with us today to talk about this increasingly now 11 days away from the start of the Trump administration. So everything that we're discussing is very much up in the air and going to be turning on a dime in a little less than 2 weeks. And we could not have a better group to help us talk through these issues, how we got here, what's going on, and what the challenges are that are ahead of us. First up, we have Professor William Carter, who's the John Murray Faculty Scholar and Professor of Law at the University of Pittsburgh School of Law, where he served as Dean for 6 years from 2012 to 2018. He specializes in constitutional law, civil rights, race in the law, and civil litigation. He is widely considered to be one of the leading experts on the 13th Amendment and racial discrimination. His scholarship has been published in law journals such as the Northwestern Law Review, Columbia Law Review, UCLA Law Review, and in books published by the Oxford University Press and Columbia University Press. His scholarly work has been cited by multiple federal appeals courts, and we get the benefit of that knowledge today. Shalini Agarwal serves as the special counsel at Protect Democracy, working to combat anti-democratic disinformation through litigation and advocacy. Previously, she was a senior supervising attorney at the Southern Poverty Law Center, working on criminal justice reform, and a staff attorney at the ACLU of Florida. She clerked for Judge David Tatel of the U.S. Court of Appeals for the D.C. Circuit. Finally, Tona Boyd, who moderator's privilege I go back a long time with. Most recently was the Associate Director Counsel, the #2 at the Legal Defense Fund. Before that, she served as Special Counsel and Special Assistant to the President at the White House, Counsel's Office in the Biden administration, where she worked to advance President Biden's agenda related to racial justice, equity, and judicial nominations, including the Supreme Court nomination of Justice Ketanji Brown Jackson. Before that, Tona was chief counsel and senior legal advisor to Senator Cory Booker on the Senate Judiciary Committee, spent nearly a decade working in the criminal section of the Justice Department's Civil Rights Division, and clerked for Judge Roger Gregory on the U.S. Court of Appeals for the Fourth Circuit. In short, yes, we have an incredible panel here today. To start, I wanted to sort of go in reverse there and start with you, Tona, and ask if you can sort of take us through the broad landscape of how we got here with the recent affirmative action case, the sort of broader attack on DEI, and 303 creative at the Supreme Court level, and how that fit into what President Trump had done in his first term, and sort of where that has led us.
Sure. Thanks, Chris. And I want to thank ACS for hosting this conversation. I'm honored to be included with such a distinguished panel. And I also want to recognize the occasion of today in commemorating President Carter. As a former Carter Center intern, it is especially poignant to be having this conversation that I think in some ways will reference his legacy. So as Chris said, I've sort of been tasked with teeing up the landscape and the tension between the protections afforded by the First Amendment and the promise of equality that's enshrined in the Constitution, both of which are vital to a vibrant multiracial democracy. We know that efforts to ensure equal opportunity and access to education and employment have long been under attack. And in recent history, I think coordinated and concerted strategies to roll back critical civil rights protections and laws have targeted almost every facet of public life, from the classroom to the workplace to the boardroom. And there are a number of recent inflection points I think we could reference in the attack on DEI, particularly as is relevant to our discussion. So I just want to take a moment to highlight a few. The first is something I think Taonga and Chris have mentioned, which is the Trump EO. So back in September of 2020, recall that President Trump issued an EO on combating race and sex stereotyping. It prohibited federal agencies, US military institutions, grant recipients, and federal contractors from engaging in speech, activities, and workplace trainings that address or promote diversity, equity, and inclusion. Those were part of a broad category of topics that were prohibited and labeled as divisive concepts. The EO was immediately challenged as unconstitutional under both the First and the Fifth Amendments by a number of civil rights organizations. And ultimately, that litigation was successful. And I think you have included in your materials the district court opinion in Santa Cruz Lesbian and Gay Community Center versus Trump. And so enforcement of the EO was enjoined in, I believe, December of 2020. In January of 2021, the Biden administration revoked the EO. So it was sort of summarily dispatched with, but I think it's important to recognize that its impact has lasted long after it was invalidated. So we've seen the EO now become a blueprint for state legislatures who have now modeled their own truth bans after language that was in the EO. And so there's been a number of bills passed, as was referenced earlier, that again target diversity, equity, and inclusion efforts in workplaces and classrooms. So employers have been prohibited in a number of states from providing diversity and inclusion trainings, and teachers have been prevented from teaching about topics about race, racism, sexual orientation, and gender identity. I know that Shalini is going to discuss litigation related to those types of bans, and specifically the ban in Florida. So I will leave that there. But I know we also talked about affirmative action, which is another key inflection point in this assault on diversity, equity, and inclusion. We know that affirmative action has been under attack for decades, and in June of 2023, the Supreme Court upended 5 decades of precedent in striking down Harvard and UNC's race-conscious admissions policies. Now, while we know that the court's opinion only addressed the use of race as a tip in college admissions, we've seen opponents of equal opportunity and race-conscious measures trying to extend the holding in that case to apply to dismantle the use of race-conscious remedies and diversity, equity, and inclusion programs across the public sphere. And so in the face of the many assaults and legal setbacks in efforts to promote and advance equal opportunity, particularly for historically marginalized communities, civil rights advocates and lawyers have been strategizing about how to address this multi-front campaign to roll back key protections and advancements toward equality. And that's particularly true in this moment where we know that there is an administration that will be coming into power in just a few short weeks that has already demonstrated its hostility to these types of programs. So one strategic question I think that has arisen is whether and how to leverage the protections enshrined in the First Amendment in furtherance of diversity, equity, and inclusion. So I think on the one hand, we've obviously seen how the court has provided broad and expansive protection to claims brought under the First Amendment, whether they are expressive association claims or protection from viewpoint discrimination, censorship, or compelled speech, or the broad latitude that's been afforded to free exercise claims. But I think we've also seen the ways in which the First Amendment has been used to subvert civil rights laws that are designed to further equality. And I think that's true, and that's what we've seen in the case 303 Creative versus Elenis, which again was another blockbuster case brought to us in the June 2023 calendar. And there, the court held that the First Amendment prohibits Colorado from forcing a website designer to create expressive designs, speaking messages in which the designer disagrees. So the petitioner there was the owner of a website design studio, and she successfully argued that she has a First Amendment right to deny website services for weddings involving same-sex couples because of her religious beliefs. And this was in spite of the state of Colorado's anti-discrimination law, which prohibited discrimination based on sexual orientation, race, and other protected categories, and the provision of public accommodations. So in 303 Creative, we saw a number of civil rights organizations filing briefs challenging the petitioner's First Amendment exception to public accommodation laws. And those briefs cited the dignitary harms inherent in identity-based exclusions from public accommodations. But now, I think in response to recent lawsuits, again, as part of this attack on diversity, equity, and inclusion, that have challenged programs that are designed to provide opportunities to historically excluded groups, we are seeing arguments being cited or citing the holding in 303 Creative in order to argue that the conduct at issue is protected under the First Amendment in spite of relevant anti-discrimination law. So I know that Professor Carter is going to explore this tension in further depth with respect to the arguments that were raised in the Fearless Fund case, which was a case that challenged, or a lawsuit that challenged a grant program for Black women entrepreneurs. So if you'll indulge me for a moment, I want to quote from Justice Sotomayor's dissent in 303 Creative. She outlined the sort of historical protection of anti-discrimination law, and she also outlines the potential peril in allowing the First Amendment to erode those protections. She wrote, "Around the country, there has been a backlash to the movement for liberty and equality for gender and sexual minorities. New forms of inclusion have been met with reactionary exclusion. This is heartbreaking. Sadly, it is also familiar. When the civil rights and women's rights movements sought equality in public life, some public establishments refused. Some even claimed, based on sincere religious beliefs, constitutional rights to discriminate. The brave justices who once sat on this court decisively rejected those claims." And then later on in the opinion, Justice Sotomayor goes on to quote Justice Ginsburg's dissent in Shelby Counter v. Holder. And she says, "Battling discrimination is like battling the Hydra. Whenever you defeat one form of discrimination, another springs up in its place. Time and again, businesses and other commercial entities have claimed constitutional rights to discriminate. And time and again, this court has courageously stood up to those claims until today." So I think that as we look for legal strategies and we talk about the hostile landscape that we face in our efforts to support race-conscious remedies and diversity, equity, and inclusion programs and to advance equal opportunity and dignity, it's important as part of those strategies to really evaluate the tools at our disposal. And I think also to determine the potential costs or risk in relying on First Amendment arguments like those advanced in 303 Creative, which the court did give legitimacy to, but which I think we also know can be leveraged to undermine civil rights protections in the long run. But I think obviously that's not the end of the story of for the First Amendment and its interplay with DEI and protecting DEI. There have been several successful viewpoint discrimination First Amendment challenges to state DEI bans. And I know that I think Shalini is going to turn to that next. So I'll turn it back to Chris.
Thank you so much, Tona. I think the real important aspect that I got from that is just the wide scope of both how many areas this comes up and just how multifaceted these arguments are and how they have sometimes surprising effects that might not be the focus at the time that a case is being litigated. And I think a great way to sort of go into that is our next panelist, Shalini. I think you have some very direct experience with what happens when you are facing one of these challenges and how you are able to not only take down one of these laws, as happened in the Honey Fund case, but also get it affirmed by an appeals court panel that included 2 Trump appointees. So I look forward to hearing sort of this take on how it is that we actually can look at litigating these challenges.
Sure. Thanks, Chris. And yeah, I'm Shalini Agarwal. My charge today is to talk to you all about the Honey Fund v. DeSantis case, which was Protect Democracy's challenge to the Stop Woke Act in Florida, and some of the strategic considerations that came up during the course of the litigation, to the extent that they can help inform future efforts under sounds like maybe to be resuscitated executive orders. To start off with, Protect Democracy, to the extent you haven't heard of it, is a nonprofit group that is nonpartisan, and it seeks to prevent United States democracy from declining into a more authoritarian form of government. And so we became involved in trying to combat the Stop Woke Act because we see it as a speech issue for employers who are constricted in having to say things only that agree with whatever the party line is. And that takes a page from the authoritarian playbook, as we've termed it, insofar as there is censorship of ideas that challenge government officials' preferred narratives. There's an attempt to muzzle independent institutions, in this case, businesses who might provide a counterweight to those government officials, and also directing outrage toward disfavored groups. And that is the premise through which we ended up getting involved in this litigation. Just to take a step back into terms of how we got here, I know folks have talked already a little bit about the Trump executive order. And, a couple of years after that order was introduced and was struck down, many states then started adopting copycat versions that, almost verbatim copied those divisive concepts, called them prohibited concepts in some cases. There was like some small variations, but most of those executive orders, are about at least 20 states that adopted these, largely focused in the Southeast, but elsewhere as well. It was pretty widespread. And most of these sort of anti-woke laws focused on K through 12, so that in schools, public schools, that teachers could not advance any of these divisive concepts, and also higher education. So public institutions, public universities and colleges, professors, administrators could not advance these concepts. In Florida, our governor, DeSantis, at the time was very ambitious. Maybe he still is, I'm not sure. But he declared a war on woke and decided that he would do these other states one better, and rather than just prohibiting the advancement of these concepts in the education space, he would also prohibit private employers from advancing any of what he termed prohibited concepts. And so that seemed to us pretty clear violation of the First Amendment. As someone has put in the chat, yes, it is an assault on the First Amendment. And in Florida, because the law targeted all three areas, it targeted K through 12, it targeted public colleges and universities, and it also targeted private employers. And so pretty quickly, a coalition of groups got together to say, okay, what are we going to do about this? And how can we sequence things to best make the dominoes fall the way we want them? And pretty quickly determined that we thought our best claims were likely related to the private employers, that it was sort of should be black letter law that private employer speech cannot be constricted based on viewpoint in this way. You might have maybe more of an argument for wherever the public is more like an employer, or the public is the one providing the education. But in the employment context, certainly that couldn't happen. We think it also should not. I mean, the First Amendment arguments also apply to the education context, but we figured if we were sequencing these lawsuits, it might make sense to start with the one that we thought was the lowest hanging fruit first, which is why we decided to file the Honey Fund v. DeSantis, focused on the provisions about private employers not being able to advance the divisive concepts first. And the hope was, let's get some good case law on this, and then maybe that will provide a hook for subsequent cases on higher ed and on K through 12. That strategy is still playing out. Hopefully that will all come to pass as we've envisioned. The concepts being prohibited, as Tona mentioned, include like implicit bias, the notion of privilege, affirmative action policies, things that might have to do with reparations or restorative justice, things that might implicate like cultural competency trainings, sexual harassment trainings, like all of these kinds of things that we think of as being pretty standard parts of the workplace culture, and also pretty innocuous, and also things that employers often do in order to inoculate themselves from discrimination claims. All of that, I think, became sort of suspect under these laws. The other challenge with the laws is that they were incredibly vague. And just like the executive order, where there was a prohibition saying, the employer may not advance, espouse, promote, a whole bunch of adjectives like that, or verbs like that, can't advance any of these concepts. However, notwithstanding any of those prohibitions, nothing prevents the employer from discussing these concepts in an objective manner, so long as they do not endorse them. And as you might imagine, that feels really contradictory and really challenging for an employer then to go anywhere near notions of race or sex discrimination or things like that when talking to their employees. So it put a significant chill. It was a very vague law. So those were sort of the obvious claims, and those are the same claims that were raised in the Santa Clara case that Tona referenced at the outset. So when the law was going through the legislature, Protect Democracy got involved in some advocacy around the law, but as I'm sure many of you know, there are always trade-offs when you're seeking to amend legislation and balancing that against trying to be in a good posture for litigation purposes. You don't want to necessarily make the law harder for yourself to challenge if you think it's going to pass anyway in some pretty toxic form. And we had heard that this was one of DeSantis's highest priorities, so it was very unlikely to change significantly. So we focused primarily on trying to make a good legislative record to ensure that it was clear that this was viewpoint discrimination. And I think, it's called the Stop Woke Act. So it is hard for it not to be clearly viewpoint discrimination, but it was helpful to have little bits in the legislative record about, okay, if an employer assigned the book, white privilege, unpacking the invisible knapsack, would that be a violation automatically? And, many legislators said, yeah, definitely, that would be a violation. So those kinds of nuggets were helpful to have for later in the case. We filed our lawsuit in June of 2022. The law was set to take effect on July 1st. And we filed, that's kind of late to file the lawsuit. In part, that's because it was really hard for us to find plaintiffs. We found a lot of businesses who were very chilled by the law, but this was in the time of DeSantis's pretty obvious retribution against various companies who had opposed him. This was at the time of Disney being targeted when they opposed his "Don't Say Gay" bill. So I guess courage among businesses was a tough time to step up and say, yes, I would like to file a lawsuit against Governor DeSantis and maybe be then targeted by him. But we were fortunately able to identify some wonderful local Florida businesses and a Ben and Jerry's affiliate that's 99% Black owned and has branches in the Tampa Bay area and a DEI trainer. So had finally identified some plaintiffs, and then we were trying to think through then how to frame the lawsuit, what kind of themes to include. And Florida's in the 11th Circuit. It is fairly conservative. And we were concerned about, we knew we were going to bring a viewpoint discrimination claim. We knew we were going to bring a vagueness challenge. We considered whether or not to bring an equal protection challenge as well, because it did seem that the basis of the law was, anti-minority bias, and there were comments in the record suggesting as much. But given the relative hostility of the circuit to intentional discrimination claims, we decided we wanted to get a quick win on the employer. The Stop Woke Act is unconstitutional, so that we could have that for potentially other challenges down the road, that we decided to just stick with the First Amendment and the vagueness claims. In addition, I think as Protect Democracy, we were seeking to reframe challenges to these laws as being, I think, there's a core of folks who are interested in social justice and racial justice, and I'm among them. But we were trying to broaden the tent of who might feel like this law is an overreach if a person did not already think of themselves as, a racial justice advocate. And so we were trying to frame it more in terms of authoritarian overreach and censorship. And so that is something that we tried to explicitly do in our complaint and in our communications about the case. The other, I guess, concern that we had was uh, the way that DeSantis had framed the law was, this is an anti-discrimination law. When employers are talking to their employees about DEI, you're creating a hostile work environment for them, and that's why they should be able to bring discrimination claims against the employer. And our concern was we want to be able to challenge this law as a First Amendment problem, but we do not want to cause any further damage to Title VII or other anti-discrimination laws. So that was like another factor that we were trying to balance. And I guess the one more thing I'll say about this is that we also tried to focus on broadening as much as possible the tent of employers who would be on our side, so that they could, there were employers who were pro DEI and some who might have been less so, but we figured all employers are probably interested in their own ability to speak. And so in order to keep that tent as broad as possible, we tried to keep the focus as much as possible on the freedom of the employer to speak. So I realize I'm going a little long, so I will try to wrap it up quickly. Our district court judge issued a preliminary injunction in August, suspending enforcement of the law. If you get a chance to read that decision, it is worthwhile. He's a very colorful judge. He compared the First Amendment law in Florida to being in the Upside Down in Stranger Things. And then on appeal, we were supported by a really great group of about 20 businesses who argued both that DEI was an affirmative good and that also as businesses, they should get to decide what they say to their employees. And then in March of last year, the 11th Circuit affirmed the ruling with the 2 Trump appointees. And I'll just read this last quote, and then Chris, I will turn it back over to you. Saying, "We reject this latest attempt to control speech by recharacterizing it as conduct. Florida may be exactly right about the nature of the ideas it targets, or it may not. Either way, the merits of these views will be decided in the clanging marketplace of ideas rather than a code book or a courtroom." Sorry, and one more thing I want to add is that the court, another piece of really helpful language in that opinion is the court swatting down the notion that the Stop Woke Act and Title VII are equivalent in any way, insofar as the Stop Woke Act only targets speech, and Title VII may have an incidental effect on speech, but that is not its focus. Okay, back to you, Chris.
No, I think I think that just goes to show how complex it is making these decisions when there is potential fallout in every direction to other laws, to other companies, to aspects of the same law, to especially when you're dealing with the various appeals court circuits that we have and that are only going to potentially get more hostile to civil rights claims in the coming years. Before I introduce Professor Carter or turn it over to him, want to allow those people who are seeking CLE credit today to know that your first code word in the password game is violin. So for people seeking CLE today, your first word is violin. On that smooth transition, I think that it's very easy, especially when you do look at the ins and outs of the litigation that Shalini gave us, to get bogged down in that. and those are all really important and have very real effects. But I also think at the same time, it's important that we step back and look at, like, outside of the last 2 or 3 years, look at the past 150 years. And we have the benefit of Professor Carter here to talk with us about sort of how this fits together in a much more broad sense with the intersection between the First Amendment, the Reconstruction Amendments, and how that got us to today, and your work on the Fearless Fund and other similar corporate litigation that's going on now.
Thanks, Chris. I appreciate it, and I hope everyone can hear me okay. Many thanks to ACS for pulling this together. I think this is a very important program, and I'm learning a lot already. So despite being a law professor, I'm going to try to be as brief as possible and just touch on a couple of themes in my research that are relevant both to the attack on equity and inclusion programs in the affirmative action space, but also attacks on speech, dealing with what I would call racial truth or racial literacy. And I'll try to do all that within 10 minutes because I really look forward to the discussion and the Q&A. So first, as Chris mentioned, I was asked to consult with a coalition of civil rights groups that were working on a case called the Fearless Fund case and thinking about some related cases. These cases were and are being brought by folks like Ed Bloom and others who have been strategically attacking racial equity programs for a very long time. And in particular, the Fearless Fund case was brought under a statute called Section 1981, which I'll talk about in a moment. But the argument in these cases is essentially this. To the extent that there are programs that focus upon economic empowerment or racial equity for specified groups, the targeting of those groups for such support violates Section 1981 for the same reason that these groups argue that affirmative action programs violate the Equal Protection Clause. That is to say, they argue that the mandate of colorblindness that has now been cemented in the Supreme Court's Equal Protection Law should similarly be extended to civil rights statutes, such as Section 1981. So it is of a piece with what has been a judicial trend in the equal protection space for at least the last 40 years, and they're seeking to make that cross the jurisprudential barrier into the statutory space and to strike down programs like the Fearless Fund, which was a program that devoted funds toward female minority entrepreneurs who are underserved by the traditional private equity market. Section 1981 was one of the statutes that was relied on in the attack against the Fearless Fund and other similar measures. And Section 1981 was originally enacted as part of the Civil Rights Act of 1866. So I need to take a moment and take a step back to provide just a little bit of context for how that statute came about and why it came about, to then be able to explain why I believe its use to attack racial equity programs is deeply, deeply wrong. The 13th, 14th, and 15th Amendments are collectively referred to as the Reconstruction Amendments. That is, after 250 years of race-based slavery and a cataclysmic civil war that was required to end the institution of slavery, the framers of the post-Civil War amendments sought to create what they called a second founding. That is, to reorient the nation away from the pro-slavery principles that had been embedded in both constitutional, statutory, and state law since the founding, to a racial egalitarian view of the Constitution as well as state law and custom that would, in the words of Senator Charles Sumner, would turn the nation away from the prior system, which was conquered at Appomattox. That is to say, the result of the Civil War was that the pro-slavery constitutional regime would no longer resist, and it would be replaced with one that was affirmatively anti-slavery, pro-liberty, and pro-equality. The Reconstruction Amendments, in their own right, were self-executing in many respects, but they also empowered Congress to take legislative action to address what the framers of the 13th Amendment called the badges and incidents of slavery. And so the 13th Amendment itself, of course, ends slavery and prohibits involuntary servitude, but its framers intended it to, and it was understood as going much, much further than just that. That is to say, its framers spoke of rooting out the lingering effects and vestiges of slavery, root and branch, wherever and in whatever form they may be found. And those certainly dealt with some aspects of the slaveocracy and white supremacist regime that are, aside from the point for today, such as restrictions on freedom of movement, unequal administration of criminal justice, the denial of enforceable family ties, or civil rights in court. But for today's purposes, a key badge and incident of slavery that the 13th Amendment's framers identified was the inability to participate and compete in the economic marketplace on equal terms with whites. And so the Congresses that followed the Civil War adopted a statute called the Civil Rights of 1866, which included the provision that's now codified at 42 U.S.C. Section 1981. Section 1981 provides, in short, that all persons shall have the same right to make and enforce contracts, to sue, to be parties, to give evidence, and to the full and equal benefit of all laws as is enjoyed by white citizens. There are a couple of things in that statutory language that I think are important and revealing. To start with the ending language, as is enjoyed by white citizens, Section 1981, not only in its context and history, but in its very language, is explicitly race conscious. It, in its very words, refers to prior racial assumptions about who was entitled to full and complete participation with civil and economic rights, that is, white citizens. And then their rights are the benchmark against which everyone else's rights must be equalized. So the notion that Section 1981, a statute that is facially, racially conscious, can be used to seek to strike down racial equity programs on the ground that they are not colorblind is simply textual nonsense. But perhaps more importantly, the context and history are important in understanding what that statute was aimed to do. So during the slave regime, of course, which represented one of the largest wealth transfers in the history of the world, free Blacks, as well as enslaved persons, were severely constrained in their ability to participate in the economic marketplace due to their race. And Section 1981 was one measure that Congress adopted that was intended to be a lever to pry open the doors of opportunity that had been shut based upon racial identity for so long. And the framers who adopted Section 1981 spoke quite directly of economic rights as being a positive right that would be enforced under the post-Civil War regime. That is to say, it was not merely a freedom from discrimination, although it was certainly that, but was also intended to dismantle and disable white cartels, whether established by law or by private custom, that had the effect of excluding Blacks and other persons of color due to their race. So these challenges to racial equity programs that try to utilize Section 1981 as a colorblindness statute akin to the court's equal protection jurisprudence are anti-textual, ahistorical, anti-contextual, and I am certain cannot be justified by any originalist reading of that statute or of the constitutional history. Secondly, and putting that aside for a moment, the other reason I was asked to talk today is to talk a little bit about some of my work about Reconstruction and the First Amendment as it may relate particularly to things like the Stop Woke Act and other restrictions on teaching, speaking, or learning truth. Just saying that, as I think Shalini noted, should make it obvious that statutes that target content or viewpoint are presumptively unconstitutional unless there is an overriding compelling interest and the means used are the narrowest possible. I know what Trump and what the states that have these laws would argue is the compelling interest. It's anti-discrimination because you are targeting whites by teaching the truth about racial history. Assume for the sake of argument that they're right about that. They're not, but assume they are. There are a couple of problems. Problem one is under standard First Amendment doctrine, that alone would be insufficient because the means used also have to be the most narrowly tailored. And when it comes to the First Amendment, what narrow tailoring requires is that the means used are the least speech restrictive. And as Shalini and Tona described, these laws are so sweeping in their language, so broad and so vague, that under standard First Amendment doctrine, they couldn't possibly be the least restrictive alternatives to achieve any goal, no matter how compelling. But secondly, my research suggests that standard First Amendment doctrine misses an important part of our constitutional history. So the traditional narrative, I think, that most law students are taught about the First Amendment is this: England was bad because it had sedition laws and prior restraints. We came to America and adopted a First Amendment that said we can't have any of that stuff. And what we said the First Amendment meant in 1791 when it was ratified is what it means today, along with the doctrine, of course, that the court has created, which elaborates on the First Amendment's meaning. The problem with that is that it skips the most intense, most extensive, and in my view, most important confrontation of the nation with the First Amendment, which was the battle of ideas over slavery. Both the rights of enslaved persons to receive information and to speak, but also the rights of free Blacks and their white abolitionist allies to seek to promote the end of slavery and freedom and civil rights, were subject to draconian, severe restrictions and punishment. Some of them were authorized by law. Many of them were carried out by the mob through lynchings, attacks, and driving people out of business or out of the territory. That chapter of our legal history is underexplored and underexamined, and the Supreme Court, in my opinion, purposefully does not, to a large extent, deal with that period of history in interpreting the First Amendment's original meaning, because it complicates the story. It complicates the narrative. It makes you stop and think about the fact that the First Amendment, while an overriding constitutional value of importance, is not the only value of importance in the Constitution. The second founding's framers, that is, those who adopted the post-Civil War constitutional amendments, however, were very clear that they believed that restrictions on the freedom of speech of enslaved persons, free Blacks, abolitionists, and unionists were a violation of the First Amendment as it would be in the post-Civil War constitutional regime. That is to say, the idea that truthful speech about race and history can be prohibited without violating the First Amendment would have been anathema to the framers of the Second Founding. They lived through a period of time where speaking of such issues could get you murdered, quite frankly, along with a variety of other legal consequences, and fully intended that the post-Civil War Constitution would be interpreted not in an abstracted manner, but in a manner that would advance what they called practical freedom. That is to say, that we would synthesize and integrate the racial egalitarian values of the Second Founding, which would be layered on top of and influence the meaning of the pre-Civil War constitutional provisions, as well as the new provisions that were themselves created. And so the last thing I'll say before turning it back to Chris is this. As to the Stop Woke Act and other similar laws, again, as I noted, they are clearly unconstitutional, even under standard First Amendment doctrine. One thing that I have been advocating in my scholarly work, as well as when I speak with civil rights organizations, is certainly lean on classic First Amendment doctrine, that is the abstracted, anti-historical, acontextual doctrine, to the extent that it helps. But you have another underexplored arrow in your quiver, which is to argue that, in fact, our Constitution should be read as a whole. And when we read it as a whole with the understanding of the goals of the Second Founding, it becomes even more disturbing to suggest that silencing speech about racial equity is not a violation of the First Amendment. Sorry, I wanted to add one other thing. It would be interesting to hear both questions as well as some discussion, though, about how to utilize the current First Amendment doctrine, in addition to my suggestion of perhaps leaning on the Reconstruction evidence as well, because the current doctrine provides quite a few helpful opportunities to utilize cases that I find to be legally wrong and morally abhorrent. So cases like Citizens United, Janus, 303 Creative, and others, by privileging the freedom of speech and association over equity, raise defenses, certainly for private businesses that could say they choose to only spend their money to support Black female entrepreneurs. And just like in Janus with union dues, my choice of how to spend my money for expressive purposes is entitled to First Amendment protection. Similarly with 303 Creative, if I design a racial equity program that is a customized and expressive component of my work, then like the web designer in 303 Creative, that is protected by the First Amendment. One can make those arguments, and they are not unreasonable under the current doctrine. I think there's an obvious danger, though, in giving those cases more play and more daylight. So I'll stop there and turn it back to Chris.
No, I think that is really helpful at sort of both setting forth a broader vision than we probably are getting today, as in outside of today. we're getting it today, but very few of our courts likely are. But also sort of the challenges as the courts go forward and these cases go forward, and in 11 days when Trump returns to office. I think that this was really helpful at laying out the broad landscape, and it has raised a bunch of questions. I think I'm going to sort of try in this last 8 minutes to pull some of the questions that people have put in the Q&A, along with some of the questions that I got from the discussion. The one thing that, before I get to them, that I would provide for the CLE friends on the chat is that your second code word is oboe. So oboe is your second code word, and the First Amendment is not limiting my ability to provide that to you. A question that we got early on that I do think is notable as much as it is notable in principle as much as it is in practice, which is what does woke and anti-woke even mean? And Tona, I don't need to go any further than just to ask Tona to respond. Tona, what have you got for us on that?
Well, I think on the one hand, that question illustrates the problem with this law, right? How is woke being defined? But I think another thing that's important to raise is when you look at the language and the type of viewpoint discrimination that is sort of rampant throughout the law, it's clear that in this case, woke seems to mean Black. So there is so much reference to removing discussions related to critical race theory, racism, topics that might make students feel bad about the past history of slave owning and slavery. And so in some ways, I wanted to bring up just one more case that I don't think we had a chance to discuss yet, which was Purnell versus Florida Board of Governors, which was another challenge to the Stop Woke Act. This was a challenge in the higher education space. And in addition to bringing the types of claims that protect democracy brought under the First Amendment and the 14th Amendment, there was also an intentional discrimination claim brought under the 14th Amendment in that case and challenge. And that was really important because it was important to bring a racial justice lens to what was going on in Florida and to really name that this bill is an attack on Black communities in many ways. And even though some of the litigation has been successful in enjoining the law, there was such a chilling effect when this law was being drafted and passed that many Black educators left Florida. Folks started to dismantle their trainings, to take down statements that were anti-racist from their websites for fear of being targeted by this law. And so I think that's just an important lens to bring as well. And in terms of what is woke, I mean, that is the question, right?
Thank you. Another question that is coming up on in a bunch of the questions is sort of I'll sort of take it more broad, and whoever'd like to talk about it can. But how does this discussion relate to current or potential attacks on LGBTQ people and gay couples and trans people? And obviously some of that comes out of 303 Creative, but I think there are larger concerns as well.
Yeah, if I could jump in on that real quick, Chris, because in fact, the article I'm working on right now deals with this. So I have an article that'll be coming out soon called Trans Talk and the First Amendment, that examines the First Amendment rights of public school students to engage in speech advocating or promoting gender affirming care in states that have banned such care for minors. And what I bring to bear, that is something that many others more qualified than me have written about already. But what I bring to bear is the lens of the second founding, the understanding of freedom of speech and equity as being intertwined rather than imposing values. And in that regard, the article notes that, there's kind of a common trope about the commonality of oppression, and none of us are free until all of us are free. All of that is true. I believe that. But there's something much more specific going on. The same organizations, the same people, the same legislators that are attacking speech about racial truth are the same ones who are outlawing speech advocating gender affirming care and who are making it illegal to counsel people on how to get an abortion. This is a single movement unified by some theory that I cannot get my mind around. But these attacks unquestionably will not be limited to one group's rights, because they haven't been. But, and this is the last thing I'll say, we shouldn't expect them to be. So in this article about transgender students' First Amendment rights, I actually start the article with a quote by Frederick Douglass, who notes that oppressors first of all seek to deny and abridge the freedom of speech as a means of solidifying their oppression of targeted groups. It has always been the first thing attacked. Because if it's not, if you cannot prevent anti-racist, pro-queer, pro-abortion speech from entering the marketplace, the risk, of course, is that that speech ultimately persuades voters to get rid of such policies. And so I believe, Chris, to your question, not only are these connected in a theoretical sense, they are part of a single strategy in terms of attacks on our rights and liberties.
Thank you so much. I really appreciate that. This conversation obviously could go on for another hour easily, and I would love to the next time everybody's in lunch, the next in DC to get lunch, or at the next ACS conference. I think this is definitely something that is both important and necessary, and will continue forward. But our time today has come to an end. Thank you so much to the American Constitution Society for holding this, to the nearly 300 of you who joined us today, to Taonga and everybody at ACS who put this together and asked us to join you, and finally to Professor Carter, Shalini, and Tona for providing us with so much expertise today. I really appreciate it, and thank you all for your time.